Welcome to the SQE Success Channel. Here we make legal revision clear, concise, and exam-ready. Whether you're preparing for SQE 1 or just brushing up on legal principles, you're in the right place. If you find this content helpful, please subscribe to the channel and hit the like button. In these videos, we will look at SQE 1 functioning legal knowledge sample questions. We will break down each question. 2. Study the legal points and applicable law. 3. Analyze each answer option. 4. Detail the correct answer and applicable law. Question 5. A company is pursuing a negligence claim against an accounting firm. The company's claim involves damages allegedly caused by negligent professional advice given by the defendant. As part of the disclosure process, the company lists several documents, including a 2-page letter from an independent financial advisor who is not a party to the litigation. This letter was discovered in the company's managing director's office, and the only existing copy is held by the company's legal representatives. The letter was specifically drafted to provide advice on preparing a formal letter before initiating legal proceedings. On what legal grounds can the claimant withhold access to this letter during disclosure? Options: A. The document is no longer under the control of the disclosing party. B. The document is protected by legal advice privilege. C. Disclosing the document would be excessively burdensome relative to the issues involved. D. The document is protected by litigation privilege. E. The document was created after the event, giving rise to the claim. Step 1. Identify the key legal issue. Area of applicable law: tort law. Which creditor has a stronger claim over the company's assets in administration? Step 2. Understand the key legal concepts. Legal principles to consider. 1. Control of documents. A party has the right to inspect documents in its control unless an exception applies. 2. Privilege. Legal advice privilege protects confidential communications between a client and its legal advisors. Litigation privilege protects communications for the dominant purpose of preparing for litigation. 3. Disproportionality. Courts may refuse inspection if disclosure is disproportionate to the issues. Step 3. Key principle. Litigation privilege protects documents and communications created for the dominant purpose of actual or reasonably contemplated litigation, provided they are confidential and made by or on behalf of a party to the proceedings, for use in the conduct of that litigation, including preparation for it. Analysis of options. A. The letter is no longer in the control of the party disclosing it. Incorrect. The disclosure right depends on control, not whether the document physically remains in the disclosing party's possession. The claimant has control because the only copy is held by their solicitor, so control is not lost. B. The letter is subject to legal advice privilege. Incorrect. The letter was written by a financial advisor, not a legal advisor. Privilege applies to communications with legal advisors, not third-party advisors. C. It would be disproportionate to the issues in the case to permit inspection of the letter. Incorrect. Disproportionality may be a reason to refuse inspection, but only if others do not apply. It's not the primary ground here, especially since privilege or control are more relevant. D. The letter is subject to litigation privilege. Correct. The letter was written with the sole purpose of advising on drafting the letter before claim, a communication made for the purpose of preparing for litigation. Under litigation privilege, such documents are protected from disclosure until the litigation is over. Control is not an issue here. The privilege prevents inspection. E. The letter was written after the cause of action accrued. Incorrect. Privilege does not depend on whether the document was written before or after the cause of action arose. Litigation privilege applies to documents created for the purpose of litigation, regardless of timing. Conclusion. Final answer. D. The letter is subject to litigation privilege. Summary. The letter was created for the purpose of preparing for litigation. Litigation privilege protects such documents from inspection until the litigation concludes. Control is not lost, even if the document is not in the disclosing party's physical possession. Summary. The letter was created for the purpose of preparing for litigation. Litigation privilege protects such documents from inspection until the litigation concludes. Control is not lost, even if the document is not in the disclosing party's physical possession. Assessment of knowledge. Now that you have analyzed the question and solution, it is important that you retain the learning points. You will now be given a couple of questions relating to contract law. Dominant purpose test. A company director sends an internal email to the finance team asking for a risk assessment report. The report is intended partly to guide commercial strategy and partly to support legal arguments in an expected lawsuit. The finance team drafts and sends the report to the company's solicitor. Can the company claim litigation privilege over the report? Can the company claim litigation privilege over the report? A. Yes, because it was sent to the solicitor. B. No, because internal company reports can never be privileged. C. No, because the dominant purpose was not litigation. D. Yes, because litigation was reasonably contemplated. E. No, because litigation privilege only applies to communications with lawyers. Explanation. Litigation privilege only applies if the dominant purpose of the document is the conduct of litigation. If it's partly commercial and partly legal, and litigation is not the dominant reason, privilege does not apply. Who can create a privileged document? Which of the following documents is most likely to be protected by litigation privilege? A. A letter from a lawyer to a friend explaining the litigation process in general. B. A note written by a manager outlining business risks during a merger. C. A consultant's report advising on how to word a legal claim letter after litigation has been threatened. D. A communication between a party and a non-legal expert, created solely to assist in preparing a legal claim. E. An email sent to the press denying liability after a dispute arises. Explanation. Litigation privilege is not limited to lawyers. Documents created by or for a party, including consultants or experts, for the dominant purpose of litigation, are protected, even if the creator is not legally qualified.